So the Supreme Court of India just did something. Well, something pretty wild. It's a real head-scratcher. In this explainer, we're going to try and unpack this paradox. How the court basically used its own advice to break its own law. This is a puzzle that, believe me, gets right to the core of the Indian Constitution. And that really is the big question, isn't it? How on earth can a court's advice, and that's all an opinion really is, be used to completely cancel out one of its own official rulings? I mean, it sounds like a total contradiction, a legal impossibility. But that's exactly what seems to have just gone down.
All right, so let's get straight to it. Here's the headline news. A Constitution bench, we're talking the big guns at the Supreme Court here, handed down an advisory opinion. And this opinion, it basically tore up a formal judgment the court had made just a few months before. Just let that sink in for a second. A piece of advice just wiped a piece of law right off the books.
Okay, to really get how we ended up in this strange situation, we have to go back to the beginning. We need to look at the case that kicked this whole thing off, the state of Tamil Nadu versus the governor of Tamil Nadu. And look, this wasn't some dry academic debate. No, this was about a real, messy political stalemate.
So what was the problem? Well, it was actually pretty simple, but it had huge consequences. You had state legislators, right? The people's elected representatives. They'd pass bills, send them to the governor for the final sign-off, and then nothing. Crickets. The governors were just sitting on them indefinitely. It was a veto through pure inaction, and it was causing a massive constitutional traffic jam.
Okay, so what happened next was a complete whirlwind. It happened so fast. Step 1, the legislature passes a bill. Step 2, the governor stalls. Total stonewalling. So step 3, the Supreme Court gets involved. In its Tamil Nadu judgment, the court lays down the law. It says this delay is unconstitutional, and it comes up with a fix. Clear timelines and this idea of deemed assent. Basically, if a governor waits too long, tough luck, the bill passes anyway. Problem solved, right? You'd think so, but nope. Then comes the shocker. A presidential reference is made, essentially asking the Supreme Court for its opinion on the very ruling it just handed down.
And this, right here, is where the story takes a turn from interesting legal case to what is even happening. I mean, the court has rules for this kind of thing, right? There are proper channels for rethinking a decision. So why, oh why, would they use this incredibly rare and, frankly, legally fuzzy tool, an advisory opinion, to second-guess a judgment that was still hot off the press? Look, think about it like this. The normal way to challenge a Supreme Court judgment is tough. It's official, you file a review petition, maybe get it sent to a bigger bench. It's the front door, with all the proper procedures. But what happened here was totally different. The government used a presidential reference. That's kind of like sneaking around to the side door and just asking, hey, just curious, what do you guys think about this? It's just not how you're supposed to reopen a case that was just decided. So what even is this thing, this advisory opinion? Well, it comes from Article 143 of the Constitution, and it basically says the president can ask the Supreme Court for its opinion on a legal question. But here's the kicker, and it's a big one, written right into the Constitution. The court may answer. It doesn't have to. It can totally just say, no, thank you. It's a request, not a command.
Now, to explain why they even took up this request, the court came up with something totally new. They called it a functional reference. Their argument was, oh, this isn't a big deal. It's just about the constitutional mechanics, the nuts and bolts. But hold on a second. There is a massive problem with that. This term, functional reference, you won't find it anywhere in the Constitution. They just made it up. And it's so vague, it's dangerous. It potentially opens a door for any government in the future to say, hey, we don't like that ruling. Let's call it a functional issue and ask for a do-over.
Okay, and this gets us to the absolute heart of this whole legal mystery. What is the real legal weight of an advisory opinion? When the court gives advice, is that the same thing as when it lays down the law? You'd think there'd be a clear answer to that, but surprisingly, there really isn't.
I mean, look at the Constitution itself. The wording is super specific. Article 141 talks about the law declared by the Supreme Court. That's the stuff that's binding on everyone, period. But then you have Article 143, and it just uses the word opinion. That's not an accident. That difference in language is huge, and it creates this massive gray area. Does an opinion pack the same punch as the law declared? So, in this new opinion, the court pulls out a quote from a really well-known case from 1978. And on the surface, it seems like a slam dunk.
The quote says that all other courts ought to be bound by one of these advisory opinions. And boom, that's their justification. That's how they give their advice enough power to knock over the Tamil Nadu judgment. But there's a but, a very big one. They kind of left a part out.
Because, here it is. Here's the full context. If you read the whole thing from that 1978 case, the story completely flips. The original judge literally says that this whole question needs to be considered more fully down the road. He even points out that a lot of smart people argue that an advisory opinion is not the same as law declared under Article 141. So, get this. The very case the court used to claim its opinion was binding law was actually a case that intentionally left the question open. Wow.
And all of this brings us right back to where we started, with this incredible paradox. The whole point of this was supposed to be about providing some clarity on the Constitution. But what happened? It's actually made everything way more confusing.
So where does that leave us? We're left with a whole bunch of really important questions just hanging in the air. We have a binding judgment that got knocked down by a legal tool that nobody's even sure how powerful it is. The court didn't even say if this new opinion is binding on itself in the future. And it neatly sidestepped a bunch of other big constitutional questions by just saying, oh, that doesn't fall into our new made-up category of a functional reference. And so we end up right back at the start with this puzzle. The goal was to provide a clear answer to a constitutional question. But in the end, by using such a strange route, by leaning on a quote taken out of context, and by leaving so many loose ends, the court has actually just created more questions. Questions about law, about power, and about the very nature of its own authority. And that's the ultimate paradox, isn't it? The search for clarity has left all of us in a cloud of even greater uncertainty.